Okay, thanks for giving me the privilege to introduce the first speaker in the person of Barrister Tamfu. Barrister Tamfu is a practicing human rights lawyer based in Douala, Cameroon. His input is going to be on the perspective of legal point of view as far as inheritance is concerned. We have realized that most of us find ourselves wanting when we find ourselves faced with challenges of inheritance, especially when our parents are no longer there. So I think Barrister Tamfu has come on board to clarify us on some of these things so that we should know, while we're going to know what our tradition says, we also want to know what the laws of Cameroon say about inheritance. Barrister Tamfu, you're welcome. You have the floor.
Thank you so much for having me today. I'm delighted to be on this program, and I think that what I'm going to share with regard to the topic will be educative to you. Like the topic itself talks about inheritance and succession. The two words look alike. We can say they are synonyms, but when you go deeply, maybe looking at it from the English definitions, you see that there's a small difference. But let's just consider it to be what happens to somebody's property after his death. And having that simple definition, I think we can say we are talking about inheritance. So, during the lifetime of somebody, the person acquires a lot of wealth, properties, money. So when he's no more, that wealth continues to who are the next of kin. And that kind of scenario within Cameroon context varies in almost all the corners of Cameroon, because there's what they call customary law. You have Muslim law, you have English law, you have civil law. So what you should understand is that Cameroon is a bijural system where you have two systems of laws that apply. And in Cameroon, there is hierarchy of norms. So, for example, if somebody, a wealthy man, for example, passes away, for example, let's say in a common law jurisdiction, that is, when I say common law, now let me first of all break it down. The two systems of law that are applicable in Cameroon, you have common law inherited from England and civil law inherited from France. So the way inheritance will be treated in a common law jurisdiction is different from the way inheritance will be treated in the civil law jurisdiction. Now, these ones are laws. There is, beside these fixed laws, you have what they call customary laws, whereby the custom as it obtains in the Wimboum tribe will not be the same, for example, in Kom, will not be the same, for example, in Garwa, or will not be the same in the east, in Betwa, because each of these communities have their customary laws. And those customary laws are also a source of law, meaning that they apply. But the problem is that they should not be repugnant to natural justice, equity, and good conscience. For example, there cannot be a custom that says that upon the decease of, for example, a wealthy man, maybe all his assets should be burnt away. No, that is against against natural justice, equity, and good conscience. So that kind of culture cannot, or customary law cannot excel. So when we have already at the back of our mind that there is customary law that can govern inheritance, it's fine. Now, and this customary law is not imposed on people. It should be agreed by the parties. So it is when the parties do not agree to be applied customary law that they will now refer to either what common law says or what civil law says. I'll take a practical example to demonstrate. I am in Ndu, for example. My father was a wealthy man. with so many properties, money, buildings, and he dies. Now, if he dies without leaving a will, in law, they said he's dead, he didn't leave any will, so he died intestate. But if he leaves a will, he died testate, that he has given a will, that is, he decided that, okay, if I'm no more, this is how I intend that my properties should be divided. So in the event that he has not put up any will, that's where maybe customary law will come in, because he didn't provide for anything, because will is regulated by statutes, that is regulated by a law. So if he dies intestate, that's without putting a will, customary comes in. Now, if the parties do not want the customary law to be applied on them, they will now go back to the common law, or what the common law provides with respect to the situation. So that's the same exercise that you have, for example, in Yaoundé, if you find yourself there and you are comfortable with this situation. So now we need to know what a will is. A will is not made after the death of the person. The will is made while the person is alive, and it has its characteristics where the person must be conscious, the person must know exactly what he's doing, and the will is not kept by him, it's kept by a neutral person, which can either be a notary public or a registrar in court. So when the person now is dead, they will now bring up the will and read. The administrator will now come in, read the will, and then see what was said according to what the dead person wanted his property to be managed after his death. So once we have that knowledge of customary law at the back brain, we should also know that there is Muslim law. Muslims also have their own way of handling inheritance. But I would like us to focus more on maybe not only focus more on common law or on what obtains in Wimum, because we already understand that there is customary law. Aside the customary law, there is also common. There's apart from the customary law that can be applicable in, for example, in the Wimum land, there is also common law that could be applicable. Now, also, if it is customary law, I don't know so much about customary law with respect to that, but the way the things are usually interpreted is that there are assessors who always help in the process. People who know the culture, because the matter maybe will be brought to court, and the judge who is sitting in the matter will not know exactly what the Wimum culture says, so he's assisted by two assessors who actually hear the parties, and then the assessors will direct him on how inheritance obtains in the Wimum land. Now, if it is not a customary law that will apply, and we have to use status, that's common law, there is an order of inheritance, meaning that the law will want to know, there is what they call which kind of family the man had. Was it a nuclear family, or was it an extended family? When I say nuclear family, I mean father, mother, and children. That's common law I'm talking about. Now, when you talk about extended family, you have uncles, aunts, grandparents, brothers, and sisters coming in. So that's extended family. So I want to take a practical example to explain. But imagine that it's not a customary law that will apply. It's common law. My father was a wealthy man. He was married to my mother, not legally. That is having a marriage certificate that he just come and stay, not legally. and he had 3 children. The first is a man, the second is a woman, and maybe the third, or I don't know, or the third could be anything. So with respect to common law, if this kind of scenario happens within a nuclear family, the common law wants to know if the woman was first of all legally married to the man. If the answer is no, she will not be able to inherit the properties of the husband. The person who inherit is any of the children of the man, of the deceased person. Now, with common law, there is no difference between male and female. Male and female have equal rights. But if it was that the man, the deceased person, was legally married to his wife, they had a marriage certificate, she will inherit from the property and be the administrator of the estate. She administers the estate, she cannot sell the properties. If it is a building, for example, she can only eat the fruits of that building. She cannot sell that building. But the children can sell, they have the right to sell. I think that's a case, that's a practical example I've taken. Now, you could also have a situation whereby the person has properties in lieu, and his last domicile, that's his last place of residence, for example, was in the US. If he dies in the US and he has properties, for example, within the Hindu, for example, it's not the US laws that will govern his inheritance. No. What will govern his inheritance is the law where the properties are found. So that's what we talk about, jurisdiction of the properties. So it is not the laws in the US that will apply, but it is the law where the properties are situated. So that's something I wanted you to also note. I don't know if I'm missing something. I want to take practical examples to explain what I want to say. Okay, I've already spoken about. Okay, now, let me go back to that example where I said a married man, in short, a nuclear family where you have father, mother, and children. Imagine the man was not married to the wife legally. The man had no children. If he dies, it's the wife who is not legally married to him will not inherit anything because she's not legally married. That's where you now have the inheritance will extend to the nuclear family. And in the list of the nuclear family, the order is this. You will have the parents of the deceased. After the immediate parents of the deceased, you now have the brothers and sisters of the deceased. And thereafter now, you can now have nephews, uncles, grandparents, if any. So when you want to talk about inheritance under common law, yes, the most important document that can give you right to any of the persons to take over, if it is a woman or a man in a union, is a marriage certificate. For the children to inherit, they must show proof that there is a link with the deceased. That they should show proof, and that can be proven maybe through their birth certificate, because they cannot inherit somebody, they cannot inherit another person's property. So you must show that you have a link with the deceased. Maybe you are his child, And if that be the case, that's when you can inherit. So
Right.
I
So
would
I
like
have a quick question, Barrister.
yeah.
Yeah, maybe before you continue with the next part, we would like to see coming the first speaker for, inheritance in the context of the Wimbum land. And if we do have many more questions, then definitely we'll be putting down these questions. And of course, Yajengala will be in charge of that. She will be like managing the questions and forwarding them to the exact speaker to intervene, or maybe any person who is capable of bringing up, many more some great ideas. So at this time, maybe with your indulgence, we'd like to call on the second speaker.